Be ready for the dictation. The dictation speed is 120 words per minute. 5 seconds to go. The Supreme Court issued notice on a plea by 6 rival MLAs of the Congress party challenging their disqualification from the Himachal Pradesh State Assembly. However, the court clarified that their disqualification will not be stayed. At the same time, it agreed to examine the question of whether the recently announced fresh by-polls should be suspended. These MLAs had rebelled against their own government led by Chief Minister by cross-voting during the Rajya Sabha election and later abstaining from the budget vote in February, setting off a constitutional crisis in the state. As a result of their endorsement of BJP candidate Harsh Mahajan, Congress leader and senior advocate lost the lone Rajya Sabha seat in the state despite a Congress majority in the assembly. On the last occasion, while agreeing to defer the hearing at the behest of the petitioner's lawyer, Justice Khanna pointedly questioned the former legislators over their decision to not approach the High Court. Notably, the bench expressed its doubts over the maintainability of this petition under Article 32, asking which fundamental rights of the petitioners were violated. During today's hearing, senior advocate Harish Salve, representing the rebel MLAs, highlighted the sequence of events leading to their disqualification. He alleged that a whip purportedly issued by the Congress party on February 15 ahead of the Rajya Sabha elections was not received by the petitioners. Over the weekend, the State Election Commission announced that by polls for the 6 vacant constituency seats will be held. We are entitled to challenge and ask for a stay of this. Also, there has been no notification, only the dates have been announced. Next, he told the court that a show cause notice was issued asking the MLAs to appear before a committee to respond to a petition seeking their disqualification. These MLAs were summarily disqualified despite an objection raised in their reply, specifically pointing out that they had not received a copy of the petition. The senior counsel claimed the judge then clarified the court's stance, stating that while it would issue notice on the plea, there would be no stay on the disqualification. We can issue notice, that is fine, but there will be no stay. Second, we won't allow you to vote and be a part of the legislative assembly. We won't even allow you to participate. However, senior advocate objected to the notice being issued and a potential stay on the fresh elections. He argued Article 329 of the Constitution has kicked in by the notification of the election. There is no question of normally staying any fresh election process. There have been 4 judgments of this court to that effect. The learned senior counsel appearing for the appellants fairly submitted that the relief granted by the High Court may not be disturbed while pressing for the reiteration of law which might guide the High Court in not entertaining such writ petitions in the future. It is further submitted that the High Court has exercised writ jurisdiction under Article 226 of the Constitution of India even after the Debt Recovery Tribunal became functional in about 185 cases pertaining to the appellants alone. After the filing of the special leave petitions, 35 writ petitions have been filed. Resultantly, the appellants are not in a position to proceed further to recover the amounts due from the defaulting borrowers, guarantors, defeating the object of the Act itself.